Welcome to Legal Lens Zimbabwe, where we untangle legal jargon like a lion untangling itself from the Serengeti bushes. Today's lesson is a wild one, literally. We're diving into the objectives and key principles of international wildlife law. Let's talk about climate change, a term scarier than your attorney's bill. It's not just about forgetting your umbrella on rainy days, it's about global, long-term shifts in weather patterns. Spoiler alert, humanity isn't winning this battle. Who's the top offender? Well, step forward, China and the USA, the heavyweight champions of greenhouse gas emissions. But we all play a part. Deforestation, fossil fuel-loving vehicles, and unchecked industrialization are part of the problem. Think of it as humanity's toxic relationship with Mother Nature. But hope isn't lost. International wildlife law gives us tools to fight back. Wetlands? Heroes in disguise, supported by laws like the Convention on Biological Diversity, CBD, and the Ramsar Convention. Such laws like CITES are mitigating against the extinction of animals caused by climate change, or CMS, that tries to assist in the conservation of migrating species, which today suffer from climate migration. Wetlands, as established in terms of Ramsar Convention, absorb carbon, reduce floods, and basically act like Earth's massive sponge. More so, Zimbabwe has enacted national laws like Statutory Instrument 72 of 2020, the Parks and Wildlife Act, and the Environmental Management Act. It is doing its part in addressing the principle of public trust. We will delve into that principle later. Let's introduce you to the climate justice principle. Imagine you spill your friend's soda and they're left without a drink. They're innocent, but they pay the price. Climate justice argues against this injustice. Those least responsible for climate change shouldn't suffer the most from its effects. And here's the kicker, climate justice isn't just about us now. It's about current generations and the generations to come. This echoes the premise behind Climate Intergenerational Equity Clause, our obligation not to ruin the planet for future humans and animals alike. We want the next generation to inherit the Earth, not a flaming desert. Sustainable development is the art of meeting our needs without destroying everything in the process. A 1987 report defined it as, wait for it, development that doesn't sabotage future generations. Revolutionary, right? International wildlife law embodies principles like polluter pays, a polite legal way of saying you broke it, you buy it. And the precautionary principle, translation, better safe than sorry when it comes to wildlife harm. Considering the fact that we are not gods and trying to fix an extinct animal or a damaged ecosystem would be outside of our realm of possibility, this principle is questionable sometimes. And now, multi-species justice. It's like regular justice, but with a heart big enough for humans, animals, plants, and all other life forms. It's not just a nice idea, it's a necessity. Did you know a court in Pakistan ruled that Kavin, an elephant, had the right to life? Yes, you heard that right. Animals have legal rights. Mic drop moment, if you ask me. So there you have it. Climate change, climate justice, sustainable development, and multi-species justice, all crucial players in international wildlife law. As much as these laws aim to save wildlife, they're also about saving us. Because, let's face it, no one wins in a world without elephants. We are not done yet. There is also environmental justice. Let's take a closer look. So, what is environmental justice? Think of it as Mother Nature's golden rule, ensuring everyone gets a fair share of her blessings, and not an unequal dose of her wrath. The concept took root in the United States back in the 1980s, sparked by shocking findings. Hazardous waste sites were disproportionately located in poor African American neighborhoods, while affluent white communities enjoyed the privilege of cleaner surroundings. It wasn't just a coincidence, it was a blatant inequity. According to the U.S. Environmental Protection Agency, EPA, environmental justice is about fair treatment of all races, cultures, and incomes when it comes to environmental laws and policies. Simply put, no community should bear more than its fair share of pollution just because it lacks political clout. Equality is the name of the game. Here in Zimbabwe, our Constitution backs environmental justice with some heavy-hitting provisions. Section 56 guarantees that all persons are equal before the law. Translation: whether you're a giraffe or a zebra, I mean, a rich landowner or a modest farmer, everyone deserves equal protection and benefit of the law. The Environmental Management Act, EMA, strengthens this by promoting participation in environmental governance. No one should be left in the dark when it comes to decisions about their environment. But environmental justice isn't achievable in isolation. It's linked to other rights: access to clean water, food, education, shelter, and, of course. Now, let's decode some principles, starting with the common but differentiated responsibilities. Sounds fancy, but it's about fairness. Developed countries, with their industrial revolutions and carbon footprints the size of elephants, are more responsible for historical emissions. They also have greater capacity to tackle the problem. So, they bear the lion's share of responsibility. And then there's the precautionary principle. It's a classic case of better safe than sorry. If there's a risk of serious environmental harm, don't wait for full scientific certainty. Act now. Think of it as the legal equivalent of not waiting for your brakes to fail before checking them. Another key principle is the polluter pays principle. If you spill your drink, you clean it up, right? The same applies to environmental pollution. EMA makes it clear: if you pollute, you pay to fix it, simple and fair. And the public trust doctrine is all about guarding nature's gifts, our air, water, and forests, for everyone. These resources aren't for private monopolies, they're treasures for all humanity. So, governments have a sacred duty to protect them. Let me give you a real-world example: Costa Rica v. Nicaragua. Nicaragua dredged a canal, damaging Costa Rican wetlands. The International Court of Justice ruled that Nicaragua must compensate Costa Rica for these damages. A victory for environmental justice. Environmental justice isn't just a buzzword, it's a call to action. It's about fairness, sustainability, and ensuring we leave the Earth better, or at least not worse, than we found it. So, let's embrace these principles and be champions of justice, one step at a time. Here's a list of other environmental law principles that should attract your attention. Firstly, we have the principle of intergenerational justice. This principle emphasizes fairness across generations. It's the idea that we, as the current generation, have a moral and legal obligation to leave the environment in a state that allows future generations to enjoy the same, or better, quality of life as we do. Think of it as borrowing the earth from our grandchildren. We need to return it without damaging the goods. This principle is a cornerstone of sustainable development and reminds us that short-term gains shouldn't come at the expense of long-term sustainability. Then there is the preventative principle. Here's where the old adage, prevention is better than cure, takes center stage. The preventative principle demands proactive action to avoid environmental harm before it happens. Instead of cleaning up after pollution has occurred, this principle insists on measures to prevent damage in the first place. For instance, stricter regulations on industrial emissions or deforestation are meant to stop harm rather than just mitigate it later. It's about being a step ahead of environmental degradation. The right to access to information. Knowledge is power, and access to information ensures that everyone, regardless of background, has the right to know what's happening to their environment. This principle empowers individuals and communities to make informed decisions and hold governments and industries accountable. Whether it's information about air quality, waste disposal, or climate change policies, transparency is key. Laws like the Environmental Management Act, EMA, in Zimbabwe promote public access to environmental data to ensure equitable and effective participation in governance. Environmental governance works best when everyone's voice is heard. Public participation ensures that all stakeholders, individuals, communities, organizations, have the opportunity to engage in environmental decision-making. This principle isn't just about listening to experts, it's about valuing local knowledge and experiences too. In Zimbabwe, laws encourage inclusive participation, ensuring decisions reflect the needs and rights of all, particularly marginalized groups. Section 4, subsection 2 of the Environmental Management Act states that participation of all interested and affected parties in environmental governance must be promoted, and all people must be given equal opportunity to develop their understanding. Skills and capacity necessary for achieving equitable and effective participation. It's democracy at its finest, applied to environmental matters. So that is it for your principles in international wildlife law, actually international environmental law in general. Thanks for tuning into Legal Lens Zimbabwe. Like, comment, and subscribe to join the conversation. Together, we can make a difference.